My name's Isabel Murphy and I'm a Senior Associate at Katanas Lawyers. I was recently involved in a High Court decision, the matter of TAC and Katanas. Mrs. Katanas was our client. She made a claim for psychological and psychiatric injury as a result of a motor vehicle accident. She was injured in July of 2010 when another vehicle collided with her car. The accident wasn't her fault. She sustained a number of injuries. She was taken by ambulance to the Alfred Hospital where she remained for a number of days. Her injuries included fractured ribs, neck pain, but secondary to the motor vehicle accident, she developed psychological and psychiatric injury for which she was treated for a number of years. Her treatment included some hypnosis to treat her flashbacks and nightmares that she was experiencing. You can't automatically make a common law claim for compensation. You first, as a plaintiff, must prove two things. Firstly, that your injuries were caused as a result of the negligence of a third party. And secondly, you must be able to show that you've got a serious injury as per Section 93 of the Transport Accident Act. Mrs. Katanas wasn't granted a serious injury certificate by the County Court judge. The County Court judge found that her mental disorder or disturbance didn't meet the serious injury test. The judge looked at mental disturbances and said on the spectrum, in order to be able to satisfy the serious injury test, your psychiatric injury must be at the upper echelon of psychiatric illnesses. We didn't feel like this was a just or fair outcome for our client, Mrs. Katanas. We believed that the consequences of her injury were enough to satisfy the test, and we were able to successfully appeal the County Court decision to the Court of Appeal. What happened next, however, was that TAC appealed our successful Court of Appeal decision to the High Court of Australia. It's not common that cases like this end up at the High Court. In fact, this is the first TAC case in the entire scheme that's ever ended up at the High Court where the serious injury test was looked at and analysed. The High Court handed down their decision in August of this year, and the High Court upheld the decision of the Court of Appeal. And that is that you don't have to be at the upper echelon having significant treatment in order to be able to prove that your psychological or psychiatric injuries are serious. If the High Court hadn't have found this, the narrative test would have changed in Victoria, and it would have been much more difficult for people who are injured in transport accidents who suffer from a psychological injury to be able to get the compensation that they deserve. The client was extremely pleased with the outcome. As soon as we got the judgment, I called Mrs. Katanas, told her what had happened. Mrs. Katanas is quite a remarkable woman. She went back and studied VC at 49 years old and went on to study an arts degree at Monash University. So the significance of this case is not lost on her, and she understands that this decision impacts not only her, but also Victorians across the board who suffer from psychological or psychiatric injuries as a result of a motor vehicle accident. The importance of this case is that now TAC versus Katanas is legal precedent. Katanas lawyers are at the forefront of ensuring that clients get just and fair outcomes, and this case, I think, demonstrates our commitment to ensuring that we get these outcomes for not only our clients, but ensuring that the rights of injured Victorians are protected. It was an absolute honour to be part of this case. To go to Canberra to instruct in the High Court was absolutely incredible, and for me, certainly a career highlight.